For accused or applicants 1 and 5, it's Advocate Mlotshwa. For applicants or accused number 2 and 4 is Advocate Volmarans. And for accused or applicant number 3 is Ms. Gilling. Matter was adjourned for further hearing today. As previously indicated, Your Worship, the state needed to file an extra affidavit from the investigating officer, which affidavit I have a copy thereof unsigned was shared with my colleagues on Saturday or Sunday. It was the 31st, Sunday night. Yes, I'm told it's Sunday night. I have a copy. I have an original for the court, and I beg leave to read same on record. I've also shared a signed copy with my learned friends. We can say it's G1, Your Worship, I think. Yes, because it's part of Exhibit G. With the rule of the court, may I proceed to reading same on the record? Thank you, Your Worship. Further affidavit in opposition to application for bail. I, the undersigned, Kumarasan Pillay, state under oath in English, paragraph 1. My particulars are stated in my previous affidavit handed in this honorable court and admitted as Exhibit G. I do not intend dealing with same in this affidavit. A. Summary of the case and evidence against the applicants, docket Beria, CAS 85 of 2023, paragraph 2. Further to my statement given on the 26th of March 2024 at about 22 hours 30, I wish to state the following as indicated herein below. Paragraph 3. Further evidence revealed that on the 10th of February 2023 at around 2300 hours 11, applicant 4 Gwabeni is placed in the vicinity of Umlazi D section through his cellular phone records. Paragraph 4. Further, there's evidence applicant 4 Gwabeni also used his visual card at around 2300 hours 25 with seconds 20 on the same day at Umlazi Caltex Nelagahle filling station situated in Umlazi W section, which is close to where the vehicles were returned. Paragraph 5. Further evidence indicate that at around 2300 hours 23 with seconds 50 on the same day, the 10th of February 2023, the tracking report of the grey VW Polo with registration number NUR 59728 places the vehicle at the very same Caltex garage. Paragraph 6. This evidence, viewed together with other evidence already mentioned in my initial affidavit, indicates that applicant 4 Gwabeni was either an occupant in the said grey VW Polo with registration number NUR 59728 or in the vicinity of the said VW Polo around the time the white Mercedes was handed back at Umlazi. Paragraph 7. The analysis of the cellular phone records further indicates communication amongst the applicants or accused themselves and also with the two Ndimande brothers currently kept at Eswatini before, during, and after the incident. That is all I wish to state. It was signed on the 31st of March 2024 and we beg leave to hand in as Exhibit G1.
So recorded Exhibit G1.
And the court. With that being said, Worship, that will be the case for the respondents on this matter.
Case for the respondents, Mr. Mlotshwa.
Places. Your Worship, the record will reveal that an indication was made that the particularly applicant number 1 and 5, though generically all the applicants will be reserve their rights to reply. However, Your Worship, there is a new development that I've discussed with my colleague, my learned colleague for the state, which relates to the ruling that was made by this honorable court regarding the Eswatini court record that it was inadmissible. When preparing a replying affidavits, we stumbled upon the affidavit requesting the arrest of the alleged fugitives in Swaziland. Your Worship, I must place it on record that when the arrest was made in Swaziland, the instructing attorney for applicant number 1 and 5, who have instructed me in this matter, I presume the same with the instructing attorney in respect of number 2 and 4, went to Eswatini for a watching brief. Upon return, we did not use those court records that relate to Eswatini. So let me now address the court specifically on the affidavit that is requesting the arrest of the alleged fugitive by the Director of High Prosecutions of KwaZulu-Natal, because it would appear that whichever way the directive of the court goes, it will have a rippling effect on how we have prepared the replying affidavits for applicant number 1 and number 5. With the leave of the court, if I may place on record the basis. Number 1, on the day of...
Sorry, Mr. Motsoane. The affidavit requesting for the arrest of the Ndimande brothers in Eswatini.
That is correct, Your Worship.
And that is what you have stumbled upon.
It is on the digital space. That is exactly what I'm trying to address the court so as to get the directive of the court in the light of this development. Your Worship.
Bearing on the applicants before court.
Yes, invariably it will also talk about the evidence that implicates the suspects, including but not limited to also 1 and 5. That is the main reason why I was begging leave to place on record the basis, and then my colleague for the state to address the court, and then so that we can get the directive from the court.
Okay, proceed.
I'm indebted to the court. Number 1, on the day of first appearance of Mr. Siyabonga Kezani Ndimande and Malusi Dave Ndimande in Eswatini Magistrate Court, the affidavit deposed to by the Director of High Prosecutions of KwaZulu-Natal Division became available on digital and media platforms, presumably leaked, thereby rendering it accessible to the general public. It has been printed out. Worthy to note in these proceedings is that to the opposing affidavit of the investigating officer, attached is affidavit deposed to by Constable Jonathan James Blaine, marked annexure KP5, regarding photo album of 25 TikTok video still images downloaded and printed. As this photo album of 25 TikTok video still images was admitted and has formed part of the court record, John Ray's saying that what is good for the goose is good for the gander becomes applicable. Put differently, like cases must be treated alike. Thirdly, the Director of High Prosecutions of KwaZulu-Natal, Advocate Elaine Harrison, compiled it in her capacity as public official, exercising a public duty for the purpose of public use by virtue of Section 34 of the Constitution that gives everyone right to have any dispute that can be resolved by the application of law decided in a fair public hearing before a court or where appropriate another independent and impartial tribunal or forum. Fourthly, the general public has accessed it since the day of it being leaked, presumably the rationale for leaking it on the day of appearance in Eswatini, as it is currently on digital and media platforms in order to influence the opinion of the public probably for excoration of individuals referred to in it, or for general public to pass judgment. 5, as required by law, it bears the signature of Advocate Elaine Harrison, clearly indicates that the investigating officer in this case is one of the officials responsible for it, and it complies with the fundamental principle of relevance envisaged in Section 210 of the Criminal Procedure Act 51 of 1977. Sixthly, the investigating officer also refers in paragraph 41 of his affidavit to the arrest of Ms. Siyabonga Kezani Ndimande, in brackets Ngele, and Dave Malus Ndimande, MJ, in Eswatini on Saturday, the 24th of February 2024 at 400 hours. A factor I respectfully submit goes directly to the heart of the relevance of this affidavit in this bail application proceedings. Number 8, the Constitution imbues the accused person with the right to challenge and accuse evidence. Number 8, though on digital and media platforms, Section 15 of the Electronic Communications and Transactions Act, number 25 of 2002, makes it admissible as it states as follows. Section 15, subsection 1 of the ECT Act, in any legal proceedings, the rules of evidence must not be applied so as to deny the admissibility of a data message in evidence on the mere grounds that it is constituted by a data message, or B, if it is the best evidence that the person accusing it could reasonably be expected to obtain on the grounds that it is not in its original form. Presumably, this is the best evidence rule it addresses. Lastly, I humbly request that this basis, I respectfully submit, Your Worship, satisfies factually, legally, and constitutionally all the requirements for admissibility in these bail application proceedings for it to be accepted. That is all, Your Worship.
So if I understand you correctly, the basis for your submission that whatever you have added in your replying affidavit should be added or should be allowed is, firstly, the affidavit which was made by the Director of Public Prosecution, Ms. Harrison, which was handed in at Eswatini, applying for the arrest of the two Ndimande brothers who are in Eswatini.
But the one that we're talking about has been downloaded on the digital space.
Okay. And am I understanding you correctly?
That is 100% correct.
Then secondly, the second leg of your application is because of the TikTok still photo album that has been handed in these proceedings. How does that link with
Your Worship, if one were to compartmentalize the evidence using the terminology my colleague used, typifying the evidence in these proceedings, the TikTok evidence forms a genre of computer-generated evidence.
Yes.
It being a computer-generated evidence, if one horizontalizes the focus, it's the same with the request for the provisional arrest of the accused. As you click the request for the arrest, it pops up. So it is on that basis, Your Worship, that if the computer-generated evidence, i.e. the TikTok, KP5, and the 25 still images have formed part of these proceedings, in law, the affidavit on the digital space, it cannot be rejected merely on the ground that it exists there on the digital space.
So your argument is because the affidavit by Ms. Harrison was on digital, it became public to the...
So it's electronic, let me put it that way. Just one. Yes, I was just trying to get one clarity. I'm not sure if the court was asking if it was ever presented in Eswatini or not.
Well, that is one of the questions.
Yes.
What was that affidavit meant for? Was it meant for the Eswatini court as an exhibit or as a request, or what was it meant for?
Your Worship, when the director deposed to the affidavit, she was requesting the arrest of the alleged fugitives. For her to comply with the international conventions that regulate both the extraditions and the mutual legal assistance, she has to indicate what evidence is there and who the suspects are. It is on that basis, Your Worship, that I will talk about accused number 1, applicant number 1, and number 5. They also feature in the request. And then that request, now it is in the public space because of it being on the digital space. There are comments, there's everything. So we are saying one of the grounds is relevance to these proceedings, and then another ground, among the grounds that I've enumerated, being that let it not be rejected by virtue of the fact that it exists on the, or it's available electronically on the digital space.
But was it meant for the public when it was drafted and compiled, the affidavit?
Your Worship, it's a right we cannot deny the public by virtue of the fact that post-constitutional liberal democracy, the right to press, the right of the media, I think it is on that basis that it is already in that space. And we are of the opinion that if the Constitution imbues the right to challenge and present evidence, there is evidence that 1 and 5 wish to present, which is contained in the affidavit, which is in the public domain, with the public, generic public now having access to it.
Yeah.
I agree, Your Worship, it's quite a technical point that has taken us. That is all, Your Worship.
Mr.
Your Worship, I tried my best to quickly write what Mr. Mlocha was saying as he was reading his points. When I was in point 3, I was already in point number 18, and I could not catch up. As a result, I would request a very short adjournment so that I can address the court properly with point by point that is being raised. Already I have my answers in my head. It's just that it would be proper that I go through it. I'd like a copy of what he has written because I could not keep up with the pace. I see it's 11:15. We can come back at 11 or 10 past 11. I'll be in the place.
I'll also do better with a copy, Mr. Mlocha, of...
As what pleases, Your Worship, I'm indebted to the court. Your Worship, it's just that the presentation had to change because it was in the replying affidavits based on the discussions that I had with my colleagues that we first addressed this aspect. I had to, as I'm reading, I had to remove those pages from the replying affidavit, but I will give the copy to my colleague. I will make this copy available to the court as well.
Perhaps you can ask for 11:15.
11:15. Very well. Court will adjourn until 11:15. general public. So it was leaked.
Your Worship, as we now live in the digital world, everybody following the case, if you take your phone, it's there. But we do not know how it landed in the digital space. It is against that background that I'm saying the presumption, which is rebuttable, is that the only way it could have landed in the digital space will be through a leak. And Your Worship, it's the type of evidence under normal circumstances. A ruling will be made that probably it be accepted provisionally, and then on merits, parties submit full heads of argument why it should be accepted permanently or why it should be, the provisional order should be reversed. So the presumption is based on the fact that in the absence of the explanation how it has landed in the digital space, one is left with nothing but presumption that it could be a leak.
Was all in agreement that that affidavit was meant for the court, not in the Republic, but in Eswatini?
Your Worship, on that aspect, I'm 100% in agreement with the courts. The only issue we have is it is relevant in these proceedings in the sense that it does touch on the evidence that implicates particularly applicant number 1 and number 5, and in this bail application, among other things that they need to do, the law is clear. They need to show this court how serious doubt exists in the state case. And constitutionally, they are imbued with the right to adduce and challenge evidence. So considering going through this affidavit, one was of the opinion that other than relevance, the interest of justice will warrant that this affidavit be presented before court. As to what weight, at the end of the day, probative value the court attaches, then it's the other issue altogether. But the door cannot be shut on the face of the applicants based on the legal instruments that I've given, I've presented before the court, especially Section 15 of the Electronic Communications and Transactions Act. It says no evidence shall be rejected merely because of virtue of the fact that its existence is not in the physical form, but in a digital form. It was on that basis, Worship, that when the TikTok 25 photo album images were presented, I had to discuss it with my instructing attorneys that legally, especially with the Electronic Communications and Transactions Act, it's a moot point if we reject it on the basis that the state, it's a computer generated evidence. Hence, we never objected to that piece of evidence. So looking at the TikTok messages that were downloaded about accused number 5, then one horizontalizes the focus now to this affidavit. And my humble request, Your Worship, is at least if it, under normal circumstances when documents are disputed with the provisional order, it helps the court to also cast a glance at the document that is in dispute to see what type of a monster it is, so that it allows the court that if the arguments are presented on merits, whether the provisional order should be affirmed as a permanent order or the provisional order should be reversed, the court is best placed to make that order. Yes, court, please.
Thank you. Mr. Kaba.
Thank you, Worship. Perhaps I should start from this fashion before I respond to what has been highlighted by Mr. Mlodjo. We need to understand what type of evidence one is dealing with. For one to use the proper tool for its admissibility, one must first understand and typify the evidence. The WhatsApp, my apologies, the TikTok messages, I scratch, not messages. The TikTok images that we have produced as evidence. What is that? It is a photo of an individual or individuals. It therefore becomes what? Real evidence. I will make an example. In a murder case, there's a shooting somewhere. The deceased is shot, is lying there. The LCRC people come and take photos of whatever is found at the scene. It is later presented to court. There's no need for the court or for the state to bring the body of that deceased to court. It will bring a photo of the deceased as real evidence that this is the deceased in that photo. These images are not computer-generated evidence. This is real evidence of a photo of applicant number one together with whomever is with. Where it was found is not an issue. It might be printed from a social media, it might be it might be a copy from a photo album. The fact remains, it's real evidence. Therefore, Section 15 of the Electronic Transactions Act do not apply. That is a starting point. Therefore, to equate or make the affidavit of Ms. Harrison to be equated as if it's like the WhatsApp images, it's incorrect. Because those are two different types of evidence. Secondly, Section 15 of the Electronic Transactions Act says, in any legal proceedings, the rules of evidence must not be applied as to deny admissibility of data messages. Now, my learned friend, Mr. Volmarans, handed us, sorry that I make an example with him because I was looking at him, a bundle, a hard copy, a bundle of what he says. This is my client's affidavit. If I decide to take that bundle, scan it into my laptop, it does not now become data-generated evidence. It does not. It was not generated by the computer as envisaged in the Electronic Communications Act. It's not. What I did is I took a hard copy that was typed, printed, and everything, and uploaded it in my system, and then sent it to every individual, or printed it. It does not change the picture that it is now data-generated message. No, it's not. Therefore, it doesn't qualify to be evident admitted in terms of Section 15 of the Electronic Transactions Act. Now, if you first understand those and typify those kind of evidence, then you are in a better space to say, now, if I have to admit this evidence, which tools must I use? It brings me back again to the application that was brought. This is a document that was meant for court proceedings in Eswatini. Eventually, it saw the light of day at the proceedings in Eswatini and became a court record of Eswatini. What happens to it after that doesn't change its picture. It's still that tiger that had all those stripes. The fact that it leaked, or somebody made a copy and decided to put it in a website of Sunday Times, it doesn't change the picture. Relevant to that, Your Worship, is, as Mr. Mlocha have said, there have been comments on what was uploaded in the system. If one has to go to those comments, they will say, these are, or this is an affidavit that was handed at Eswatini court. Because that's where the reference is all about. Not that it was generated in a computer, therefore becomes data message, therefore admissible in terms of section 15. It can't be. The fact remains, this is a court document that was handed in Eswatini. If you want that document to be admitted in court, use the proper rules and tools of its admissibility. This is the issue that the court has dealt with before, and the court has made a ruling. That is as simple as it is. Do not try to equate it to something else which is not there. It's not going to help. Understand the evidence, typify it. After you have done that, what rules are there for its admissibility? That's the bottom line. Now, admit it provisionally, sit back, look at your ruling, scratch it with a lead pencil, not a red pen, so that if needs be, you lose a rubber and say, this is my ruling. I do not agree with that, for the following reasons. Even in what manner the application is brought, it hasn't changed the color. It hasn't changed the nature. It hasn't changed how or why you typify that document to be. It has not changed. If there was a change, then you would say, let me sit back. Perhaps I might say, let me provisionally allow it. But it hasn't changed. It's still the same thing. I will make an analogy. Once again in a criminal trial, Your Worship, there will be a trial for the admissibility of a confession. The court makes an interlocutory ruling to admit the confession. The court will wait for any further evidence that might be led during the trial, that might change the complexity or the nature or in whatever form why that statement was admitted in the first place. I will make an example. The accused said, I was assaulted. Unfortunately, at this stage, I can't find my J88 from the doctor. That showed that I was assaulted. At the time the criminal court make a ruling to admit the confession, the J88 is not there. And it admits it because there's no evidence before it. Later on in the trial, the accused gets the J88 and said, you remember, Your Worship, I said I was assaulted. Here's my J88. Then the court will look at that evidence and say, but I made an interlocutory ruling for the admissibility of the confession, but here's evidence that supports that indeed the police assaulted him. Before judgment is given, or at judgment, the court can say, I'm now saying the ruling that I made on the confession is now inadmissible because something has changed. What has changed here? The fact that now it has been changed from being a court record to be a computer-generated evidence, which is not. What has changed here? Nothing. Why are you requested time and time again to go back to your ruling instead of people having to do what they're supposed to do? Bring the evidence in a proper way. Maybe that will be a change. Maybe the court can say, now I'm convinced the evidence is brought in a proper way, I will admit it. For example, on paragraph A on this page, on the day of the first appearance of Mr. Siyabonga Kezani in Demande and Malusi Dave in Demande in Eswatini Magistrates Court, the affidavit deposed to by the Director of Public Prosecutions of KwaZulu-Natal became available on digital and media platforms presumably leaked, thereby, rendering it accessible to the general public. It has been printed out. It gives an impression that this evidence even became available even before the arrest of applicant number 1. Because this became evidence on the day of the arrest of applicant number 1. Matter was postponed for bail application, which started on the bail started on the 18th, if I'm not 19th of February, if I'm not mistaken, Your Worship.
This bill application.
This bail application.
On the 14th.
On the 14th, yes.
March.
On the 14th of March. Way after this evidence became printed out or in the media or leaked, whatever you call it. The applicant who now comes before you, or the applicants that now come before you, are saying, even though in our initial application we did not use it, we had it. It was in our possession, we had it. And we decided not to use it. Then you made a ruling that you are not going to listen to anything that comes from Eswatini. They are aware of that. They are coming today and say, but we had it in the first place, but because now it changed its form, is no longer a court record, it's computer-generated evidence, then you can admit it. It can't be. It can't be. I have indicated on what is noted on paragraph B of this page about KP5 to say those are stills of images showing an individual. How do you term that? It's real evidence, not documentary evidence. It's real evidence. Now, what is more important, Your Worship, is what is mentioned by the same applicants on paragraph C. The Director of Public Prosecutions of KwaZulu-Natal, Advocate Elaine Harrison, compiled it in her capacity as public official exercising a public duty for the purpose of public use by virtue of Section 34 of the Constitution that gives everyone a right to have any dispute that can be resolved by the application of the law decided in a fair public hearing before a court or where appropriate another independent and impartial tribunal or forum. It was meant for the court. Hence, this court was informed. That affidavit forms part of court proceedings in another country. Anyone who wants to use those court proceedings must follow the rules of admissibility. Mr. Vormarans had an issue with the state last week about using Annexure D. What did the state do? Immediately we made a copy of the court record, which is a charge sheet in another matter, have it certified by the clerk of the court, brought it to court according to terms to Section 235 of the CPA. It was admitted. The general public has accessed it since the day of it being leaked. Presumably, the rationale for leaking it on the day of appearance in Eswatini is as it is currently on digital and media platforms in order to influence opinion of the public for exoneration of individuals referred to in it and for general public to pass judgment on individuals referred to in it. I don't know why we have that paragraph. We have submitted before you, Your Worship, what we are of the view is relevant for your decision at the end of the day, whether the 5 applicants should be released on bail or not. Whoever says whatever outside this court should not influence either of us in coming to that decision. Whoever printed this and had his own intentions, not for this specific court. The relevancy of this paragraph escapes me. As required by law, it bears the signature of Advocate Elaine Harrison, clearly indicates that the investigating officer in this case is one of the officials responsible for it, and it complies with the fundamental principles of relevance envisaged in Section 210 of the Criminal Procedure Act 51 of 1977. Very well said. But what are we referring to? We are referring to an affidavit in the court proceedings of another country. Relevant or not, it's up to you. Bring it to court in a proper way. Bring it to court in a proper way. Until such time that same is brought in the proper way, perhaps the court can revisit its ruling about its admissibility. The investigating officer also refers in paragraph 41 of his affidavit to arrest of Siyabonga Kezani Ndimande, Ngele, and Dave Malusi Ndimande MJ in Eswatini on Saturday, the 24th of February 2024 at 400 hours. A factor I respectfully submit goes directly to the heart of the relevance of this affidavit in this bail application proceedings. Warrant Officer Pillay said, of the suspects that my evidence or my and my team's evidence suggests we should arrest, these are the people. Upon tracing Siyabonga Kezani Ndimande and Dave Malusi Ndimande, the information was that they were in another country. I therefore started a process by approaching the office of the DPP to assist in having them extradited back into the country. There is no mention in his affidavit of the contents of the application. Nothing. The relevancy thereof, of the arrest in the bail application before court, based on what Pillay is saying, I can't find it. Pillay is simply saying, those are my suspects. I can't find them in South Africa. I made the request that Eswatini must arrest them, period. Nothing more said on the affidavit by Advocate Elaine Zungu to make this application relevant. That because Pillay has mentioned it, that's why I'm saying. But Pillay has not said a word about the contents of the affidavit. Merely to say there was a process that was engaged. How then the process changes to be relevant in the sense of now speaking to the contents of the affidavit, I can't find it. We can't find it. We went through our affidavit when we asked for the court for the adjournment, we can't find that. Therefore, Your Worship, you cannot, with the greatest of respect, use a wrong tool for the admissibility of another evidence. Section 15 is not applicable at all in these proceedings, insofar as trying by all means to have an affidavit admitted. I've put my phone on flight mode. I'm just going to read, Your Worship, what the meaning of data message is. The Electronic and Communications Act gives legal recognition to any data message. A data message is defined under the ECTA to mean and include a data generated, sent, received, or stored by electronic means, including videos, or rather including voice, where the voice is used in an automated transaction and stored records. Basically, the affidavit, can we classify it as data message to be admitted in terms of Section 15? Unfortunately, we can't. On those bases, nothing is put forward for this court to reconsider its initial ruling of saying, I'm not going to allow evidence to be heard in this court from Eswatini. Therefore, on those bases, still in the same picture, and the application should be refused. If I can just approach my learned colleague. I'm further reminded of one specific crucial point. In the initial application for the admissibility of this evidence, albeit that it was made by Mr. Volmarans for applicant 2 and 4, on the same basis, actually, indication was made, Your Worship, that we as the applicants are in the dark as to what kind of evidence are we facing or that the state alleges they have against us. Therefore, we cannot meaningfully make our application because there's that lacuna or lack of information. The state then said, a time will come where we will have our affidavit ready, indicating which evidence the state has against you. You will then be given an opportunity to reply to what the state has now alleged. I remember myself saying, be patient, wait until that time. As and when it comes, you'll be given that opportunity. We have done that. Last week on Wednesday, a 65-page document was read on record, indicating the evidence, as Mr. Mlotshwa has indicated, that even Ms. Harrison's affidavit talks about the evidence. We have given the evidence in Exhibit G and supplemented that with Exhibit G1 to say, this is what you said has been lacking. Therefore, the reason for us to be here today, as Mr. Volman rightly put, we will reply to what you have said in your answering affidavit. That is why we are here. Is there any reference on Exhibit G or G1 of an affidavit and contents thereof of Ms. Harrison's affidavit? Nothing. Your Worship, once more, I'm sorry to say this, but it appears to us that this is another way of trying to get this evidence by the back door. Unless there's anything else that Your Worship wants me to address more, those will be my submissions.
Mr. Mlotshwa, first and foremost, before you reply to what Mr. Tsawa have said, why do you refer to your submissions as new developments? Because this affidavit was available as on the 24th of February 2024. Why do you say it's new developments?
Your Worship, newness is attached to it on the basis that, as my learned colleague for the state has addressed the court substantively, among other things, he says there was a point where he had to admonish the defense to hold on because there will be time that the state will present its full-blown argument through the investigating officer of Viva Voce why bail is being opposed. My colleague is 100% right. The state has done that. And that if the state has done that, we are now becoming aware that we have to reply to certain amendments that are contained in that affidavit. That being the case, Your Worship, in the world of law, other than a great deal of unanimity that the accused has got a right to challenge evidence, one is able to derive guidance from the Supreme Court of Appeal in State versus Tebello, 2010, Volume 1, SACR 55, Paragraph 55, where the Supreme Court of Appeal ordained that during the bail application, the accused must, on a preponderance of probabilities, prove that the state case is non-existent or subject to serious doubt. Replying to the state amendments, on the digital space, one finds a document that is even not disputed by the state.
Sorry, Mr. Mlocha, I have to interrupt you on this one. My question to you is, your opening statement is, Your Worship, there has been new developments, and by new developments you refer to a document which was in existence as on the 24th of February 2024 in a Swatini court, and which was meant for a Swatini court.
Your Worship, there are two aspects. We were aware of a hard copy that was existing, that was never used. It became a new aspect when it was brought to the attention that other than that hard copy that was not used, on the phone there is this, it is against that background that one has to attach a tag to it as a new development, because at the time when there was information that there is a hard copy, we were not aware that there is also a digital, an affidavit that is on the digital space.
But it was your submissions that Ms. Harrison had to put this on media for purposes of extradition, because the only way he could get it over to Eswatini was through making it available on digital. Was that not your argument or your submissions?
Your Worship was explaining the mutual legal assistance and the extradition process. That invariably, whichever way that request would have been put across, because with these two legal processes, you'll always have these two parties, the requesting country and the requested country. In this instance, South Africa, RSA as the requesting country, had to indicate what evidence they were having. That being the case, Your Worship, I put it on record. The instructing attorney went to Swatini for a watching brief, but when they came back, we didn't use that. And then when we are busy preparing for the reply, it comes to our attention that, hey, on the digital space, there is an affidavit there. As one peruses the affidavit, you can see it bears the signature of the DPP, it refers to the investigating officer in this matter as one of the officials responsible for the affidavit. It has got evidence, including but not limited to applicant number 1 and applicant number 5. Your Worship, my colleague talked about the provisional order. With the provisional order, it happens daily in our courts. Firstly, as my colleague has correctly pointed out, during within a trial, the judicial presiding officer will make an order that provisionally I will accept this, subject to anything happening in the proceedings. But I think my colleague forgot to mention the second leg, where the judicial presiding officer will say, due to the issue that is being debated, during the merits, I will ask all the parties to submit the heads of argument fully, why the provisional order should be reversed or should be made permanent. My colleague makes example of a real evidence. Mathematically speaking, he missed the boat up to no decimal point there. Reason being that the canons of interpretation are to the effect that if you reason by analogy, the example that you cite should be cognate in all material respects. We are making reference to the document that is on digital space.
I've made a ruling long time ago that no photos should be taken of the accused persons whilst the court is in session. I've noticed you say that you keep on taking photos of the applicants, and that is disrupting the applicants in concentrating on what is being said. And I take exception to that because I've made a ruling. Please desist from doing that. You are disturbing us, you are disturbing the accused, you are disturbing everyone. Thank you. I'm sorry about that. Mr.
As the court pleases. Your Worship, if I may take the court to KP 5, particularly paragraph 2.1 and 2.2. Your Worship, as one casts a glance at 2.1, the police official constable, James, says a TikTok video with username at user, he gives the digits. 2.2, he says the same. That being the case, Your Worship, if one follows the literal grammatical meaning that in terms of the interpretation of statutes we must follow, it fits the definition that my colleague is giving of a data in terms of the Electronic Communications Act. The photos that he presented, according to James, they were videos. It was on that basis and strength that we were saying we viewed them as computer-generated evidence. We couldn't object because it allows the Electronic Communications Transactions Act a computer-generated evidence to be presented. But if my colleague says it was presented just like a corpse or a knife as a real evidence, that is where I was a bit confused. That is where I was a bit confused. Most importantly, Your Worship, there is no submission by my colleague as to the prejudice that the state will suffer if this affidavit is either accepted provisionally or accepted permanently. And my colleague says, relevant or not, to him that is not important. And here, the accused, in terms of the law, they've got this responsibility to discharge. And the accused are giving the instruction that, among other things, in discharging this duty, this responsibility that we shoulder, present this affidavit. It's up to the state whether they file a supplementary affidavit denying that it is the DPP affidavit, denying that the evidence analyzed there was not analyzed by the DPP. In a nutshell, Your Worship, the predicament we're facing is, at the end of the day, the right to present evidence so as to meet or satisfy this requirement, it will be gravely disturbed if the DPP affidavit is not allowed.
In what way does your application to have the DPP's evidence in a Swatini court, admitted in this court, differ from the application which was made on behalf of applicants represented by Mr. Volmarans?
Even though I did not want to get into merit, if you compare the affidavit deposed to by the Director of Public Prosecutions and the affidavit that has been deposed to by the investigating officer, Mr. Pillay, chalk and cheese in terms of exaggeration, in terms of the informer's evidence. And it is my humble request that it was at the end of the day when we argue on merits in terms of the weight, the probative value that must be attached.
But what I mean is, the evidence that Mr. Volmarans was trying to put into this court was the evidence which was tendered in a Swatini court. The court ruled that evidence the court is not prepared to accept. So the affidavit that you're talking about is the affidavit or is the evidence that was tendered in a Swatini court for that court to decide on the issue or on the matter involving the two people in Eswatini. So my question to you is, in what way does your affidavit or your evidence differ from that of Mr. Volmarans?
Yes, if I understood my colleague's request, it was the court record for Eswatini with the affidavit, with the notes, things that aroused concern as to who would have even made the notes. That was the hard copy that we also had from, that I also had from the instructing attorney that we never used. Then if you go on to the digital space, the one that I'm talking about, it's a clean affidavit, except that it bears the signature that purports to be that of the Director of Public Prosecution, and there are no notes that are made on it. And it shows at the end that the investigating officer is one of the officials responsible for the document.
But it was the evidence meant for Eswatini court, the evidence which was tendered in Eswatini court. Correct?
I agree, Your Worship.
Yes. So how can we receive it this side?
Your Worship, my profuse apologies, otherwise I'll come across as a broken record. It is on the basis of the 9 grounds that I furnished, including the Electronic Communications Act, Section 15 that I quoted, in terms of which it says this document cannot be rejected merely because it exists digitally. And my colleague has read the definition of a data. And my humble submission is, you look at paragraph 2.1, 2.2 of KP5, it states clearly, the TikTok was downloaded as a video. It satisfies all the requirements of a computer-generated evidence. You look at this affidavit by the Director of Prosecutions. You just click on your phone, you say request for, it pops up on the digital space. As you go through it gives all the details, who the DPP is, it analyzes the evidence, it shows how the DPP believes that there is evidence. And on that basis, we are saying, when the evidence is analyzed in that affidavit, the evidence is analyzed to include the applicants who wish, 1 and 5, who wish that the affidavit be presented before this court. That is all, Your Worship.
Okay. Thank you.
Just 2 issues that Mr. Mlochwa raised which give concern. I think if left unattended, it might give a different, if I can be allowed, that's all I'm requesting, an indulgence, before the court makes a ruling.
Very much reluctantly, Mr. Kaba.
I perfectly understand, my lord. 1, Mr. Mlochwa has unfortunately, in his submissions, made a fact that what is contained in the proposed affidavit that they want to be admitted and what is said on Exhibit G, trying to give some kind of credibility on the 2, which aspect I think you should have stayed away from before the court sees the contents thereof. The second part,
But Mr. Mlochwa's argument is to the effect the applicants are called upon to reply
yes,
to the allegations that are made against them.
yes, Your Worship.
And this is an attempt on their part to reply. And in replying, they are using whatever that is available or that is at their disposal to reply to the allegations that are made against them. Otherwise, they would be criticized for not having replied to the allegations made against them.
In all intents of purposes, Your Worship, they should do that. I have not changed my stance for once. I said, if you want that evidence to be admitted, use the proper way of having it admitted. That is all I've said from the onset. They have to follow the procedure. The problem that they are having is you want that to be handed in. It is a court record. It is a court record. Follow the procedure of how you have that admitted. That's all. I'm not saying they should not use it. And let it be clear, Your Worship, I did not object to Mr. Volmaran's admissibility of that evidence, solely on the basis that there were notes. I made the reference to say there are even notes on it for us to say is this the proper record or not. It should be clear, Your Worship, if they want to use that, follow the procedure. How do you have that evidence handed in court? You know what you're supposed to do. I'm coming to KP5. I'm astonished. I will try to explain my point as best as I can.
I'm aware of the principle argumentum ad hominem, principle that prohibits playing the man, rather the ball. My colleague requested to make further submission reluctantly. The court, I think the horse has already bolted out based on the camel's nose into the tent approach. The camel is already now in the tent. At the end of the day, I'm not sure if we will be allowed again to reply to what the state is submitting.
Unfortunately, I have to.
As the court pleases.
Thank you. The second gentleman with the camera in this beige or orange t-shirt. If I'm standing here and I take a photo of him or a video of him with whatever device I'm using, he is standing there. He is dancing with his camera, whatever. It is real evidence. That is what you see. If I take that video and load it in my WhatsApp, in my TikTok and whatever, it does not change. It doesn't become computer generated. It's still that real evidence that you saw, is that I took it and put it in another platform. Therefore, you cannot use section 15 of the Electronics Act to say this is computer generated. It is not. It is on those bases that he's saying this is where I sourced this real evidence. Not to say I've sourced a computer generated evidence. No. It's a video that is there, posted by someone as real evidence. It shows that man standing there dancing behind his camera. That is all. Your Worship, it has to be clear. We are saying these are the documents that form part of a court proceedings in Eswatini. Our KP5, if I'm not mistaken, were the records of the court proceedings in the Durban Magistrates Court. We handed it in court as an attachment. It complied with all the relevant rules of admissibility. It's a charge sheet that the person in whose custody is kept has certified it to be correct, and it was handed in. If they can do what they are supposed to do in order to have those proceedings handed in, there won't be an objection. Until such time that that is done, that evidence is not admitted in the proper way in court. Not that you should not use it to challenge a state's case. Use it if you so wish, but follow the proper court proceedings. That's all I was saying. Thank you, Worship.
Very short this time around.
Maybe to guide you and put me and put you to where I want you. Why don't you follow the procedure used in handing in KP6?
Your Worship, it's unfortunate that if I answer the court's question without first addressing this aspect by my colleague, my submission would be decontextualized.
Okay, fine. Go ahead.
As court pleases. Your Worship, if one looks at they call it fundamentology, the beginning of the beginnings, how the Electronic Communications Transactions Act came into being. You look at all the cases starting in 1982, there was a problem that once whatever evidence is intended to be presented in court, once it has gone through a device, the rudimentary principle is breached, the best evidence rule. If it is presented in court, it's no longer satisfying the best evidence rule. What did the legislature do? There were so many problems of fraud cases, of corruption cases, of money laundering cases that will require people to send SMSs. If the best evidence rule was still followed without following the Electronic Communications Act, that was not going to be admissible in court. It's against that background that after all those cases, I remember Ken That's why I was saying if the court were to give us an opportunity, I can give cases and heads of argument. At the end of the day, to circumvent the best evidence rule principle is section 15 that I have cited for this court. Where is it captured? Section 15. Most flabbergasting, my colleague is saying I've not followed the procedure. That is exactly what I'm doing in terms of section 15, subsection 1B specifically. I will read it again. Section 15.1, in any legal proceedings, the rules of evidence must not be applied so as to deny the admissibility. That is exactly what my colleague is doing. So as to deny the admissibility of a data message in evidence. B, if it is the best evidence that the person adducing it could reasonably be expected to obtain. So, to cut the long story short, Your Worship, I followed the procedure. But to cast the net wide, I have to give the constitutional reasons, the right to adduce evidence, to challenge evidence. I've given this court the mammoth task the accused are having. Matebula saying they must be given that space, that opportunity, to demonstrate at least that the state case is subject to a serious doubt. They've compared the two affidavits. We never wanted to argue without this court having the affidavit in front of it. Alternatively, Your Worship, if the affidavit is not accepted, I will argue in the alternative that we are allowed to refer to the evidence that is contained in that affidavit to satisfy this requirement when we address the evidence of the investigating officer, Mr. Pillay. That is all, Your Worship.
My concern is that the affidavit that you propose handing in is part of the record of the proceedings in Eswatini court. And after you have handed in the affidavit, I will not have the benefit of the proceedings in Eswatini court.
Your Worship, that is not the case. What will happen is, if this court were to accept it, based on our diarteram partem rule, obviously, my colleagues will be afforded an opportunity. Among other things, they can just file a one-line saying, that is not the DPP affidavit. All we are saying, Section 210 of the Criminal Procedure Act says, any evidence relevant to prove or disprove is relevant. I've addressed that. I've indicated how it becomes relevant. When the evidence about and against the accused is encapsulated in the same document, and the accuser of the opinion that if this piece of evidence is presented before the court, we will be able to satisfy the requirement set out in Matebula and a number of other cases in the bail jurisprudence. But if the door is shut on the accused, I foresee a possibility, Your Worship, of the accused being unable to do what the law requires them to do. The element of prejudice, Your Worship, it has never been addressed by the state, except that the state is now hinging on the fact that it was made for Swaziland. We have established how it becomes relevant here. We have established how the digital space is making it admissible in these proceedings.
Ruling. I'm concerned and disturbed by the fact that the affidavit that the defense on behalf of applicant 1 proposes to hand in the defense own submission, it was presumably leaked to the media, and that is how it became a general public. It became accessible to the general public. And I'm concerned about the fact that it was meant for the Eswatini court, and it is evidence in Eswatini court, and this court does not have the record of the proceedings of Eswatini court. So if this affidavit is admitted, the court will then have a piece or some piece of the evidence that was tendered in that court without having the advantage of or the benefit of having all the evidence that was tendered there so as to have a complete picture of what evidence was tendered and what the applicants intend doing. But having said that, the paramount factor here and the main factor is that the applicants should reply to the allegations which are made against them in whatever way so as to show what they are alleging is the case, namely that the state case is against them is weak or is non-existent. But that doesn't take away my concern that the affidavit is not a complete picture of what transpired in a Eswatini court. For that reason, I will provisionally allow the affidavit. I will make a final ruling when in the main judgment.
As court pleases. As court pleases. Your Worship, in the light of the court's directive, we will need maybe 15 minutes to bind all the documents together so that it can be read onto the record.
Mr.
I have no objection to that, Worship. Just to place on the record that at an earlier stage of this bill application, we indicated that should we come to this stage and certain new evidence is then led, we will request a chance to respond to that. I just want the court to be clear on that. Because Mr. Lotra has even indicated in his submissions that we are open to reply to whatever they may allege, because this is now new evidence before this court. Okay. But you can take the agenda.
Your Worship, I think it's one of the legal processes with the motion application proceedings. Once closed, my colleague can make perhaps an application to supplement.
Corrections.
request the court to return the affidavit so that they can be certified and they can take back the originals. Another aspect, Your Worship, my colleague for applicant number 3 has indicated that a request is being made that we follow the as the accused appear here in court, that after number 1, she be given an opportunity, even though we had not requested the court after number 1 that number 3 be the next one.
If she insists, she can do that.
As the court pleases. With the leave of the court, if I may hand up the original.
Thank you. That would be Exhibit H.
As court pleases, in the Magistrate Court for the District of eThekwini, held at Devon, case number 23/2156 of 2024, in the matter between Lindokuhle Thabani Mkhwanazi, first applicant, Lindani Zenzele Shisela Ndimande, second applicant, Siyanda Timyeza, third applicant, Mziwe Themba Harvey Kwabeni, fourth applicant, Lindokuhle Lindo Ndimande, fifth applicant, and the state as the respondent. First applicant's replying affidavit in support of application for bail. I, Lindokuhle Thabani Mkhwanazi, the undersigned, hereby state under oath and submit the following. Paragraph 1. My personal circumstances are as contained in my founding affidavit filed in support of my bail application, Exhibit B. Paragraph 2. The facts to which I depose are within my personal knowledge unless otherwise stated or the context so indicates. The propositions of law herein are advanced on the advice of those representing me. 3. The introduction, 3.1. I have heard the opposing affidavit of the investigating officer, Warrant Officer Kumarasan Pillay, herein after referred to as the investigating officer, being read into this court's record on the 27th of March 2024, and I've also had an opportunity to read it with the assistance of my legal representatives. 3.2. My counsel placed on record after closing my case in respect of the application for bail that I reserved the right to file a replying affidavit in the event that there are aspects in the respondent's opposing affidavit which warrant and require a reply. 3.3. There are aspects in the investigating officer's opposing affidavit which require a reply. As it will be demonstrated hereinafter, that certain allegations made by the investigating officer are vague and misleading, while others are plainly wrong. Paragraph 4. Deferment of certain portions of the investigating officer's evidence to trial for determination of their admissibility and credibility, including but not limited to annexures to investigating officers' opposing affidavit. 4.1. After both parties had closed their case relying upon affidavits during my other bail application before the learned magistrate, Mr. Singh, in case number 23/13377 of 2023, the learned magistrate called the investigating officer in the case, who happens to be the same investigating officer in this matter, to testify in terms of Section 60, subsection 3 of the Criminal Procedure Act 51 of 1977. This section empowers the court hearing bail application if it is of the opinion that it does not have reliable or sufficient information to reach a decision on the bail application, to order that such information or evidence be placed before the court. 4.2. The learned magistrate, through the attention of the investigating officer, to paragraphs 3.9 and 5 of my affidavit, which is also attached to the charge sheet annexed to my affidavit in this matter, in order to get comment from him on these two paragraphs. In these two paragraphs, I averred as follows. 3.9. For lack of better words, detectives are literally clutching at straws in this matter, in that they don't have anything to link me to the offenses, especially if regard is had to the time lapse between the incident and my arrest by the police. 5, though I'm a layman, but I've also confirmed with my legal representative that the state is skating on a thin ice as it doesn't have evidence linking me to the offenses. 4.3, in response to specific and direct clarity-seeking question by the learned magistrate as to what evidence the state has against me, the investigating officer confidently replied to the learned magistrate question that, among other things, investigation in this matter is largely assisted by informers. 4.4, having heard and read the opposing affidavit of the investigating officer in this bail application, the conclusion becomes irresistible or inescapable that, other than the fact that the investigating officer's certain allegations contained in his affidavit are unbalanced, biased, vague, misleading, and plainly wrong, they hinge largely and heavily upon the information gathered from the informers. I will identify those portions of allegations herein as I deal with the investigating officers answering affidavits, paragraphs, seriatim. 4.5, in actual fact, I've been informed by my legal team, and I now understand fully, that the court cautioned in State v. Van Wyk, 2005, Volume 1, SACR 41, SCA, paragraph 6, that bail proceedings are not to be viewed as a full dress rehearsal for the criminal trial. And during the bail application, the duty of the court is merely to assess the prima facie strength of the state case against the applicant as opposed to making provisional finding on the guilt or otherwise of the accused. The making of credibility findings of witnesses on the merits of the case against the bail applicant is left to the trial court, which will ultimately be better placed to assess the evidence in its totality. 4.6, inherently, failure to defer certain portions of investigating officers' allegations to trial for determination of their admissibility and credibility will amount to naked usurpation of the trial court's powers. 4.7, I aver that I am informed by my legal advisor that this deferment of certain portions of evidence to trial for determination of admissibility and credibility happens with regularity in bail application proceedings. 4.5, consequently, I humbly request that this honorable court, during the assessment of the evidence, to defer certain portions of investigating officers' certain allegations and annexures to the investigating officer's opposing affidavit to the trial court for determination of the admissibility and credibility. 4.9, in paragraph 3 of his opposing affidavit, the investigating officer states that he has been advised that as applicants, we are bringing an application to be released on bail, and that his affidavit is intended to place before this honorable court facts and factors to be considered against our release on bail. The state, the investigating officer continues, in opposing the release on bail for the reasons and factors that are indicated in his opposing affidavit. 4.10, I hasten to add that during our first appearance in this court, the state indicated when being requested by my attorney, Mr. Dlamini, to advance grounds for opposing our admission to bail, that this was a Schedule 6 matter. Again, at the commencement of the bail application proceedings, the state did not place on record the grounds for bail opposition. In this regard, I draw the attention of this honorable court to paragraph 7.2 of my bail affidavit, and I humbly request this honorable court to view and construe paragraph 7.2 of my bail affidavit as incorporated herein. 4.11, it was during the arguments between the State Council and applicants for counsel that we heard for the first time the two reasons being given by the State Council, namely fear for witnesses and flight risk. The grounds for opposition of bail, therefore, were advanced fully for the first time only in the opposing affidavit of the investigating office. 4.12, as a result of me not knowing the grounds the state relies upon in its opposition to bail, I sought advice of my legal representatives, which advice I accepted that the Constitutional Court ordained in State versus Dlamini, State versus Dladla and others, State versus Hubert, State versus Skitegat 1999 to SACR 51, paragraph 75 and 76, that an applicant in a bail application is given a broad scope to establish the requisite circumstances, whether they relate to the nature of the crime, the personal circumstances of the applicant, which is the accused, or anything else that is particularly cogent. 4.13, redolent with non-disclosure of grounds of opposition to bail is that the state did not have grounds to oppose bail in this matter, but the state formulated the grounds while this bail application was in progress. A flip-flopping or kaleidoscopic position that even forced the state to present evidence that is materially and seriously at variance with the averments contained in the affidavit, to which Advocate Elaine Harrison deposed to on the 22nd of February 2024, requesting the provisional arrest of the alleged fugitives in Eswatini. 4.14, before juxtaposition to demonstrate differences between the evidence the state has presented in this bail application opposing bail and the affidavit deposed to by the Director of Public Prosecutions in this division of KwaZulu-Natal in the request for provisional arrest of the alleged fugitives, I aver that the affidavit of the Director of Public Prosecutions of this division is admissible in these bail application proceedings on the basis of one or two or more or all of the following grounds. A, on the day of first appearance of Mr. Siyabonga Kezani Ndemande and Malusi Dave Ndemande in Eswatini Magistrate Court, the affidavit deposed to by the Director of Public Prosecutions of KwaZulu-Natal Division became available on digital and media platforms, presumably leaked, thereby rendering it accessible to the general public. It has been printed out. B, worthy to note is that to the opposing affidavit of the investigating officer attached is affidavit deposed to by Constable Jonathan James Blaine, marked annexure KP5, regarding photo album of 25 TikTok video still images downloaded and printed out. As this photo album of 25 TikTok video still images was admitted and has formed part of the court record, John raised saying that what is good for the goose is good for the gander becomes applicable. Put differently, like cases must be treated alike. C, the Director of Public Prosecutions of KwaZulu-Natal, Advocate Elaine Harrison, compiled it in her capacity as public official, exercising a public duty for the purpose of public use by virtue of Section 34 of the Constitution that gives everyone right to have any dispute that can be resolved by the application of law decided in a fair public hearing before a court or where appropriate, another independent and impartial tribunal or forum. D, the general public has accessed it since the day of it being leaked. Presumably the rationale for leaking it on the day of appearance in Eswatini, as it is currently on digital and media platforms, in order to influence opinion of the public, for excoriation of individuals referred to in it, and for general public to pass judgment on individuals referred to in it. E, as required by law, it bears the signature of Advocate Elaine Harrison, clearly indicates that the investigating officer in this case is one of the officials responsible for it, and it complies with the fundamental principle of relevance envisaged in Section 210 of the Criminal Procedure Act 51 of 1977. F, the investigating officer also refers in paragraph 41 of his affidavit to arrest of Siyabonga Kezani Ndemande Ngcele and Dave Malusi Ndemande MJ in Eswatini on Saturday, 24 February 2024 at 400 hours, a factor I respectfully submit goes directly to the heart of the relevance of this affidavit in this bail application proceedings. G, the Constitution imbues the accused person with the right to challenge and accuse evidence. H, though on digital and media platforms. Section 15 of the Electronic Communications and Transactions Act number 25 of 2002 makes it admissible as it states as follows. Section 15, subsection 1. In any legal proceedings, the rules of evidence must not be applied so as to deny the admissibility of a data message in evidence on the ground A, that it is constituted by a data message, or B, if it is the best evidence that the person accusing it could reasonably be expected to obtain on the grounds that it is not in its original form. 4.15, I humbly aver that I have satisfied factually, legally, and constitutionally all the requirements for admissibility in these bail application proceedings for it to be accepted as an annexure G to my replying affidavit. 4.16, the affidavit was deposed to by the Director of Public Prosecution KwaZulu-Natal 2 days prior to the execution of arrest in Eswatini. On 22 February 2024, in the request for provisional arrest affidavit, Advocate Elaine Harrison stated in paragraph 13 that it was approximately 17:30 when the first deceased and his entourage were transported to the Wish restaurant situated at 98 Florida Road, Morningside, Durban, KwaZulu-Natal, South Africa. After sitting in court in the bail application proceedings, the investigating officer deposed to an affidavit stating in paragraph 15 that it was approximately 1800 hours, 18 minutes when the first deceased and his entourage were transported to the Wish restaurant at 198 Florida Road, Durban, KwaZulu-Natal, South Africa. 4.17, Advocate Elaine Kuzwayo states in paragraph 17 that it was approximately 2200 hours, 10 minutes when the deceased and his entourage, accompanied by the second deceased, exit the restaurant through a passageway leading onto a pavement on Florida Road. After hearing bail application evidence, time changed. The investigating officer states in paragraph 20 that it was approximately 2200 hours, 18 minutes when the first deceased and his entourage, accompanied by the second deceased, exit the restaurant through the passageway leading onto a pavement on Florida Road. 4.18, again, well pronounced are differences between paragraph 22 of the DPP affidavit and paragraph 27 of the investigating officer's affidavit. I aver that the DPP affidavit does not mention me, Siyabonga Kezani Ndimande Ngcele, and Dave Melus Ndimande Mj at all in paragraph 22, but the investigating officer mentions our names in his opposing affidavit after hearing evidence in court. DPP states, paragraph 22, cellular phone records were obtained for Spamandla Ngcobo and compared with cellular records at the scene of the matters on the night in question. It was established that Ngcobo had communicated with Gwabeni, see reference Gwabeni paragraph 12, and Lindani Zenzele Ndimande Shisela. Lindani Zenzele Ndimande cell phone records were obtained and he was placed in the vicinity of the Florida Road where the matters had taken place, and the investigating officer alleges in paragraph 27, cellular phone records were obtained for Spamandla Ngcobo and compared with cellular phone records at the scene of the matters on the night in question. It was established that Siyabonga Spamandla Ngcobo Mkansa had communicated with applicant 2 Lindani Zenzele Ndimande, herein after referred to as Shisela, Siyabonga Kezani Ngcele, and Dave Melus Ndimande Mj prior to murder. The cellular phone records of applicant 2 Shisela, Dave Melus Ndimande Mj, applicant 4 Gwabeni, and applicant number 1 Tabani were obtained, and they were all placed in the vicinity of the Florida Road where matters had taken place and at the time of the shooting of both deceased. There were other areas where the said cellular phones were placed on the day which are relevant to this case. 4.19, paragraph 24.3 of the DPP's affidavit refers to a grey Polo and a grey Hyundai I-10. An investigating officer in paragraph 29.3 talks about grey VW Polo with registration number NUR 59728, hired and paid for by applicant 4 Gwabeni, and the silver Hyundai I-10. 4.20, I respectfully implore this honorable court to also meticulously read and peruse the affidavit of Advocate Elaine Harrison, as I and my legal team have done so, and upon closer perusal, It is as clear as a day that the only evidence linking me to the offences is an allegation in paragraph 24.10 of driving a Polo on the evening following gunshot injuries of applicant 3, and an allegation in paragraph 27 that around 1800 hours on the 11th of February 2023, the cellular phone records place me and co-applicants in the vicinity of applicant number 4's house, as well as 133,000 rand payment, for which I have an explanation that I provide hereinafter. Throughout her affidavit requesting provisional arrest of the alleged fugitives in Eswatini, those are the only 3 thin pieces of allegations against me in relation with this matter. 4.21, in juxtaposition, it is clear that the affidavit of the Director of Public Prosecutions appears to be more objective, as there is nothing that evidences her personal interest in the matter. Presumably, she deposed to it mindful of her oath of office to discharge her duties without fear, favor, and prejudice, as opposed to the opposing affidavit of the investigating officer, which is riddled with sweeping generalization allegations gathered from informers who possibly rely on gossip mongers and rumor mongers. It is on this basis that I'm galvanized to aver that the detectives in this matter are literally clashing at straws, desperately to link me to the offences. 4.22, I humbly implore this honorable court not to attach any probative value to the investigating officer's infatuation with Muti if and when he opposes bail application. In this regard, I respectfully draw the attention of this honorable court to paragraph 7 on page 27 of annexures to my bail application, where the same investigating officer alleged during my other bail application before the learned magistrate, Mr. Singh, that among others, in that case, I was tasked with responsibility to bring Muti. I'm of the view that again, it was an allegation he procured from his informers. The learned magistrate, Mr. Singh, admitted me to 5,000 rand bail regardless. Again, in this bail application, paragraph 24.8 of his affidavit refers to his discovery of Muti in the back seat. Noteworthy is that the investigating office does not even lay the basis of the conclusion of this Muti claim he makes recklessly in bail proceedings. 4.23. Supremely significant is the fact that during my other bail application before the learned magistrate, Mr. Singh, I stated in paragraph 4.5 and 4.6 on page 40 of annexures to my founding affidavit in this bail application that upon arrival in Durban, in an area known as Isipingo, if I'm not mistaken, around 1900 hours, the police assaulted me and choked me, instructing me to make confession statement to the murder of a well-known musician, Mr. AKA. Throughout the investigating officer's affidavit attached to my founding affidavit in this bail application on page 26 to 34, the investigating officer never disputed or denied my claim of assault by and in the hands of police. I aver that the investigating officer's terse denial for the first time in this bail application in paragraph 42 of his answering affidavit ought to be rejected by this honorable court on the following basis. He has not advanced cogent reasons why he did not deny it in the other bail application affidavit before the learned magistrate, Mr. Singh, but decided to deny it now in this bail application. B, even though there are attachments to his affidavit, there are no attachments such as occurrence book, police pocket book, automatic vehicle location known as AVL, the police car's tracking record, and possibly cellular phone records of police who arrested me, indicating their whereabouts around 1900 hours as a rebuttal to my assertion that I was indeed assaulted in or around Isipingo area around 1900 hours. There is no explanation as to why affidavits were not obtained from the police who arrested me, confirming that I was not assaulted. Cellular phone records. Regarding the cellular phone records evidence referred to by the investigating office, my direct reply to all the paragraphs that make reference to cellular phone records evidence, that the investigating officer has expressed this type of evidence in extremely hyperbolical terms and even exaggerated their strength in this case. On exactitude front, I understand that the cellular phone evidence never gives an exact location. However, it all depends upon the available cellular phone tower, provided the cellular phone tower is within 4 to 10 kilometers radius. Accordingly, for instance, the allegation by the investigating officer, amongst others, in paragraph 21, that the cellular phone places me in the vicinity of the crime scene where both deceased met their death, I dispute such allegations by the investigating officer. 5.3, I've been advised that the legal position regarding cellular phone evidence is as enunciated by Kachala AJA in State versus Molimi and another, 2006, Volume 2 SACR 8 SCA, paragraph 16, that while incriminating, creating a strong suspicion of his complicity in the events of the day, the cellular phone records will not, in my view, without any further evidence, have created a sufficient basis to convict him. Again, it was reiterated by the Constitutional Court in State versus Molimi and another, 2008, Volume 2 SACR 76 CC, that the evidence contained in the cellular phone records, while incriminating, would not, without further evidence, having created a sufficient basis upon which to convict the applicant. 5.4, I dispute any suggestion by the investigating officer to the effect that the video footage will be of assistance in this case on the basis that, at a common sense level, if the video footage was of that great assistance and clearly visible to identify the alleged suspects, there would not be this long delay to execute arrest in connection with this matter. Though there are attachments to his opposing affidavit, but conspicuously absent among attachments is the video footage. I'm advised that in Moi versus the state, in brackets 162/12, close brackets, open brackets, 2012, close brackets, SZASCA, my apologies, handed down on 30 May 2012, Sneijder JA, before upholding bail appeal, considered that according to the investigating officer who testified for the state in opposing the bail application, the events recorded on the CCTV recording accord with accounts of witnesses and incriminate the applicant. The recording was not shown to the court. Despite the confidence of the state in its evidence against the appellant, it was evident that the investigating officer overstated the case during the course of his evidence. 5.5, under normal circumstances, the state indicates the source of information, whether it is from an accomplice witness or eyewitness or witness warned in terms of Section 204 of the Criminal Procedure Act 51 of 1977. I therefore aver that the allegations, among others, contained in paragraph 29.1, 29.2, 29.3, 29.4, 29.5, 29.6, 29.7, 29.8, 29.9, 29.10, 29.11, 29.12, and 29.13 have been sourced from the informers in line with the investigating officer's evidence in the other bail application that their investigation is assisted greatly by the informers. 5.6, I dispute any suggestion by the investigating officer to the effect that I knew or did something with Mercedes-Benz referred to in his opposing affidavit. I have no knowledge about it. 5.7, regarding my arrest, I respectfully ask the Honorable Court to take note that in paragraphs 42 and 43, very little is explained about my arrest, and the investigating officer has deliberately avoided giving details like where I was arrested, where I was taken to, how many hours the arresting officer spent with me, how many members of the SAPS arrested me, when and where I was eventually detained. In the absence of these significant details regarding my arrest, including the assault in order to extort a confession statement from me, must be accorded preference over the investigating officer's vague and terse explanation. 5.8, for the reasons I've aforementioned, that cellular phone does not provide exact location, I dispute the exaggerated evidence of the investigating officer in paragraph 52 that analysis of the cell phone records show that I and applicant 4 were occupants of a Mercedes-Benz. I have no knowledge of the Mercedes-Benz the investigating officer is referring to in his opposing affidavit. 6, asthma medical certificate. 6.1, I am an asthma sufferer and currently I'm receiving medication, including the asthma pump at the Westville Medical Prison Section. I challenge the investigating officer to go to Westville Health Prison Section to uplift my file, as my legal representatives could not be given the file without an order of this honorable court. 6.2, the investigating officer is so desperate to ensure that I do not get bail, elected to take a long trip to verify the medical certificate with Dr. Moodley, instead of first investigating whether or not, both in truth and fact, I am an asthma sufferer. 6.3, contrary to paragraph 86 of the investigating officer's opposing affidavit, to the effect that I am in good health with no known illnesses, I am currently on asthmatic medical treatment at Westville, and my asthmatic health condition is known by Westville Health Prison Section personnel. Hence, there is also physical file in that health section regarding my asthmatic medical treatment. Annexa KP5 by Constable Jonathan James Blaines, 25 TikTok still images photo album. 7.1, an untruth has also been told by the investigating officer in paragraph 143. This paragraph terribly exposes the investigating officer's version as a bare-faced lie. Furthermore, no basis, factually and legal, was laid for admissibility of this piece of evidence. 7.2, it is evident from the images that one Ngubeko is the individual who posted in relation to the above mentioned images. I do not have any knowledge of how this individual came to be in possession of these images in question. 7.3, I also fail to understand and comprehend what is written at the bottom of each image and who actually wrote it. 7.4, I respectfully request this honorable court to rule that it is irrelevant as it does not comply with the relevant provisions of Section 15 of the Electronic Communications and Transactions Act. Furthermore, to rule it irrelevant on the following basis. A, the investigating officer alleges that he and his team came across some social media platforms showing me brandishing a rifle and showing off with it. He further states it as a fact. He further states it as a fact in this paragraph that he and his team do not have any document indicating that I have a valid license for this firearm. I pause to assert that this version is a lie. The investigating officer got this information from his informer, took it as a gospel truth from the informer, never verified it through the investigation, and took a risk of stating it as a fact under oath, thereby exposing himself to the criminal offenses of perjury and defeating the ends of justice. Had the investigating officer conducted investigation as prescribed by law, just at a desktop level, he would have found that, C, on the 14th of October 2021, I was awarded a proficiency certificate by Mbogoto Security Solutions Pty Ltd after successfully completing a course in knowledge of firearms, handling and using a handgun, handling and using a self-loading rifle or carbine, and handling and using a shotgun. In this regard, proficiency certificate I'm referring to is attached as Annexure H. D, on the 22nd of June 2022, South African Police Service issued me with competency certificate to possess self-loading rifle / carbine, pistol / caliber, handgun and shotgun, signed by Colonel P.N. Skakane with parcel number 05201306. In this regard, competency certificate is attached as Annexure J. E, on the 7th of July 2023, I was awarded a Grade E Security Course Certificate, attached as Annexure K. F, on the 14th of July 2023, I was awarded a Grade D Security Course Certificate, attached as Annexure L. G, again on the 21st of July 2023, I was awarded a Grade C Security Course Certificate, attached as Annexure M. In total, I dispute the choreographed allegations by the investigating office. 7.6. The investigating office, by stating it as a fact in paragraph 143, that he and his team do not have any document indicating that I have a valid license for the firearm depicted in KP5, whereas in truth and in fact I have such license, the investigating officer has prima facie committed an offense of perjury and defeating the ends of justice. A, according to C.R. Snyman, Criminal Law, 6th edition, page 332, perjury is common law crime consisting in the unlawful and intentionally making of a false statement in the course of a judicial process by a person who has taken the oath or made an affirmation before or who has been admonished by somebody competent to administer or accept the oath or affirmation or admonition. And B, C.R. Snyman, Criminal Law, 6th edition, page 327, opines that defeating or obstructing the cause of justice crime consists in unlawfully and intentionally engaging in conduct which defeats or obstructs the cause or administration of justice. 7.7. Accordingly, I humbly request this Honorable Court to make an order that I be assisted either by members of South African Police Service or Independent Police Investigative Directorate to open up a criminal case docket of perjury and defeating the ends of justice for full-scale investigation to be conducted with the culminating point being charges against the investigating office. Prima facie versus strong case. 8.1. After careful analysis of its case, it is worthy to note that in paragraph 55, the investigating officer alleges that there is prima facie case against me as opposed to strong case. He says the same thing against applicants 2, 3, 4, and 5 in paragraph 60, 65, 75, and 81. I respectfully submit that this statement by the investigating officer does not address the thrust of my assertion in my bail application and in this replying affidavit that the state case is weak against me, especially the plethora of information that the investigating officer gathered from his informers, which greatly diminishes the property value of his evidence. 8.2. In the other bail application, the investigating officer visited my traditional homestead and spoke to both my mother and father. The allegation that I was not staying at home after release on bail again is false. Most flabbergasting about this allegation of me not staying at home after 5,000 rand release on bail is that the investigating officer has not disclosed his source, nor did he indicate that he spoke to my parents or my siblings or my wife. The conclusion I make is that he sourced this information from his informers. 8.3. The less I talk about what the investigating officer alleges in his opposing affidavit as having been allegedly said or pointed out by me, the better. I've been advised by my legal team that it is unconstitutional, especially if regard is held to the fact that even in his opposing affidavit, nowhere does the investigating officer state that he explained my constitutional rights. Obviously, because he never explained any of my constitutional rights. Legal challenge of charges that vitiate strength of the state case. 9.1. Regarding conspiracy to commit murder and murder, count numbers 1 and 2, there is no dispute of facts. The investigating officer never denies my averment in my bail affidavit that the former is an inchoate, formally defined offense, while the latter is a complete, materially defined crime. Therefore, my averment that the rule of practice is that the former normally features as alternative to the latter ought to win the battle of sovereignty. 9.2. In respect of all attempted murder counts, Again, my averment has never been challenged, that the state case relies upon sheer theorization. That is exactly what the investigating officer is doing in an effort to try to explain those counts. 9.3, during the other bail application, when the learned magistrate asked the investigating officer if there were firearms recovered with ammunition, because those were also charges against me, the investigating officer was so honest to tell the magistrate that it was the idea of prosecutors that was also confusing him. Paragraph 10, cherry picking, de-emphasis, and decontextualization to charge with money laundering in respect of 803,000 rand. Regarding money laundering, firstly, paragraph 10.1, the investigating officer has not disputed my A, B, and C points enunciated in my bail application, in my bail affidavit. Therefore, my averment that without these three A, B, C points, no court will convict on these counts, and in the event my legal representative do not apply for discharge after the state case, the presiding officer will mero motu return a not guilty verdict. 10.2, most importantly, the 803,000 rand deposit into applicant's force account appears not to be the only deposit the depositor made, as there were other deposits made prior to this deposit. Therefore, it is a legitimate deposit, but in order to cast aspersions, the investigating officer just adopted pure cherry-picking approach of ignoring or neglecting the other deposits in order to de-emphasize the legitimacy of the normal business transaction, which has the effect of decontextualizing normal business transaction, thereby giving a distorted picture about the transaction. 10.3, I aver that I have succeeded in satisfying requirement according to the Supreme Court of Appeal in State versus Matebula 2010, Volume 1, SACR 55, paragraph 55, that the accused must, on a balance of probabilities, prove that the state case is non-existent or subject to serious doubt. Though in this interlocutory bail application, the standard of proof is on preponderance of probabilities and proof beyond doubt in the main trial, I have shown beyond all doubt all the charges, all the dangers inherent in placing reliance upon the investigating officers ipse dixit, that it cannot be accepted holus bolus. In actual fact, Lechoti J, in DJVV and others versus the state, case number A721/2010, handed down on 17 November 2011, remarked that the court hearing bail application should apply caution where investigating officer is expressing opinion which may not necessarily be in line with evidence contained in the docket. 10.7, I do not dispute that for security work I rendered without being paid over a period that I was paid eventually 100,000 rand by the fourth applicant. Furthermore, I got married on the 26th of February 2023. In an African culture, there is something called isipego or ukupegisa, which may be anything, including but not limited to it being in monetary value. Hence, it was deposited referenced, if I'm not mistaken, as wedding. 10.6, the personal circumstances, the reasons I've given for release on bail, my undertaking to comply with any terms and conditions accompanying release on bail, and the fact that I've demonstrated how doubtful the state is, make out a clear case that exceptional circumstances exist which, in the interest of justice, warrant my release on bail. Hanke AJA in Scott Crossley versus the state, open brackets, 2007, close brackets, SCA 46 RSA, paragraph 7, held that the court must consider all facts and determine individually or cumulatively they constitute exceptional circumstances which will justify the release on bail. Wherefore, I respectfully ask this honorable court to admit me to bail with terms, conditions, and amount this honorable court deems appropriate, dated and signed at Durban on this second day of April 2024, each page initial and signed before a commissioner of oaths. Your Worship, in the interest of time, the attachment are at the back of the replying affidavit.
already marked the replying affidavit on behalf of applicant number 1 as Exhibit H. It's so admitted.
As court pleases, that is the case for the first applicant.
Thank you.
Just before I stand up, I thought the court was going to confirm the contents with applicant 1.
Yes, sorry. Thank you, Mr. You confirm the content of the statement, replying affidavit by yourself, read into the record. It was not interpreted to you here in court. Was it interpreted to you before it was read into the record? Thank you.
Thank you. I just want clarity on one aspect, Your Worship. We don't want to be said maybe we misinterpreted or there's a document outstanding. My learned friend has read on the affidavit of applicant number 1 all the allegations against the investigating officer on the perjury and all of that relating to the investigating officer said they do not have documents confirming that applicant 1 has a valid firearm license. I see there's been reference to competency certificates, something that says you are competent to possess this. Maybe my learned friend might have forgotten. Can they offer us the copy of the valid license, not the competency license, so that we deal with the request of opening charges against the investigating officer? Because the competency certificate is not a firearm license. If we can be offered with the copy, if it's available. I'm just saying this because I might have missed it. Maybe they do have, so that it can be attached on Exhibit H that they do have in following up the allegations of perjury.
Your Worship, I'm instructed that it's the competence and the certificates that I write onto the record.
But do those documents amount to a license?
Your Worship, that is the point for argument. I'll have to take further instructions on that.
So can we for now accept that you do not have a license, as we all understand and know the firearm license, but you're going to argue later on?
Your Worship, as the affidavit is before this court, the attachment is everything as far as I understand the applicant number 1 is everything.
I'm raising this question, Mr. Mloja, because there has been a direct question and concern alerting you maybe on omission from your side. That's why I'm asking this. There has been an alert raised by Mr. Kaba that you may have perhaps omitted to attach the license.
Yes. Just one, if the court may bear with
Okay.
Your Worship, if I may be given leave to approach the...
Certainly.
I'm giving instruction to the...
Certainly.
And Your Worship, can it be clear that we're relating to the rifle, so that because the IO in his affidavit related to a rifle. As the court pleases, Your Worship,
I think it's a point that we will argue. Otherwise,
Okay,
yes.
let's leave it there.
Yes, but that is the case for applicant number 1.
Let's leave it there.
That's all the clarity we needed.
Thank you. Ms. Gilling, you insist.
I don't think I do, Your Worship. We have, it's very short, it's 11 pages, Your Worship.
Okay,
For
fine.
10. If I may proceed, Your Worship.
Take the floor.
I was here all day. If I may hand the original up, Your Worship.
This is on behalf of applicant 3,
3, Your Worship.
Edi Mieza.
That's correct, Your Worship.
Right, it will be received into the record as Exhibit J.
It's not I, H-I. J, oh J, yes, because we don't use I. My apologies, Your Worship. If I may proceed, Your Worship.
You may proceed.
I, Elisiana Mayeza, major male, residing L028 Paula Crescent in Mlazi, and currently unemployed due to me remaining in custody for a lengthy period, awaiting my bail application, do hereby make oath and state as follows. The content of this affidavit falls within my personal knowledge unless the context indicates otherwise and are true and correct. Where I refer to legal principles, I do so on advice of and in consultation with my attorney. The State filed a supposing affidavit in answer to my affidavit in support of bail. I herewith file my reply to the State's opposing affidavit. I deny that I was employed as a security officer and or bodyguard by applicant number 4, Mr. Gwabeni. I was not employed by him and did not receive payments from him for sale. My apologies, Your Worship.
Your Worship, may I be excused, Mr. Nkera will be here. I don't want the court to agenda. I'm just answering to a call of nature, Your Worship. I don't want to delay the proceedings.
It is not alleged by the State that my co-accused and I are family nor friends. There is nothing before this Honourable Court to show that we have any relationship nor friendship. The alleged link between myself and my co-accused is alleged cell phone calls made on the day. This link is circumstantial evidence that seeks an inference of conspiracy to murder, attempted murder and murder. Inferences must be drawn from fact, and such inference must be the only inference sought to be drawn. See Maleba versus SA 226-214, 215, ZAFSHC 61, 19 March 2015 below. The excerpt of that is the inference sought to be drawn must be consistent with all the proved facts. If it is not, the inference cannot be drawn. The proved facts should be of such they exclude every reasonable inference from them, save the one sought to be drawn. If they do not exclude other reasonable inferences, then there must be a doubt whether the inference sought to be drawn is correct. The trial court will be asked by the State to consider all circumstantial evidence, which is all the State has at present, and from same drawn inference that I conspired to murder the 2 persons, further that I murdered Mr. Forbes and Mr. Motsoane, and that I was in possession of a firearm or firearms at some stage before, during, or after the incident. Circumstantial evidence in respect of conspiracy to murder, murder, attempted murder, possession of firearms is that there were spent 9mm casings on the scene of the incident. The presence of spent shell casings thus serve as the circumstantial evidence to infer that firearms were present and discharged. This is the inference the State is seeking to have drawn by this court and will be by the trial court. Such inference will be absolutely absurd, and I submit that no court would draw the sought inference. The State is at this time asking this court and will be asking the trial court to infer that there were firearms, that the firearms were capable of being discharged and were in fact discharged by myself or my co-accused on grounds that there are spent casings found on the scene. With reference to count 4 being unlawful possession of semi-automatic firearms, to wit 2 9mm caliber firearms or pistols, and that I have no license or permit to possess same. I am alleged to jointly possess same with my co-accused. The principles of joint possession is discussed in my founding affidavit, Exhibit C, and applies evenly. The State sought to draw the court's attention to the firearm for which I was charged in Mlazi and due to stand trial in the latter part of this year. The State alleges that the said firearm is the firearm used in these offences and that there is a second firearm but same was not recovered. Count 5 refers to myself and my co-accused being in joint possession of at least 6 9mm live rounds of ammunition, I presume Umlazi Bekitema Case 138-423 is the reference to live rounds in this matter, the firearms sought to be linked to this case. Annexure 8 to my founding affidavit, the second and third pages, contains the charges referred to in Umlazi Bekitema Case 138-423 in respect of the alleged firearm linked to this offence as counts 1 and 2. Bekitema Case 138-423 refers to a firearm that is prohibited, serial number filed off, to wit, a 9mm Star Norinco. This case refers to a semi-automatic pistol. No further description is given as to the make and no reference is made to the serial number being obliterated. It is not referred to as a prohibited firearm. Bekitema Case 138-423 refers to joint possession at count 1. The count reading, the accused did unlawfully and jointly have in their possession. The circumstances described by the investigating officer Parbu at page 16 of the transcript, lines 8 to 24, clearly speak of 6 other persons that were arrested for possession of the said firearm. This amplifies my submission that the joint possession is alleged. Had I been in personal possession of the firearm, I would have been the only person arrested for sale. Page 19 of the transcript, line 19 to 25, is material, in that the investigating officer corrects the presiding officer when he says, when she says, can you confirm, paragraph 5, that there's a possibility that the applicant before court is linked to 7 cases of murder? He states that the firearm is linked, to which the court replies, the firearm is linked, my apologies, and he confirms, yes, your worship. It is clear that the state is relying on the firearm in the Bekitema case being the same firearm that was used in the commission of this offence. Parbu was, however, not committed to linking me to any of the murder cases. He simply proceeded with possession and the state prosecuted accordingly. Had the firearm in the Bekitema case been positively linked to this offence, one would have expected the state to have added murder of Mr. Forbes and Mr. Motsoane as counts 3 and 4 and added my co-accused in this matter as co-accused in the Bekitema case. This was not done. I submit that the Bekitema case stands frail at trial and the firearm in that case is not linked to this case, leaving the state without any firearms, just spent casings. Following the proposed thought process of the author of the charge sheets in both these cases discussed, one can then safely presume that the state wished to add a count of unlawful possession of ammunition based on the ammunition recovered in the Bekitema case. It is alleged that I was in possession of 4 live rounds in the Bekitema case. In this case, count 5 refers to possession of at least 6 live rounds. Joint possession of firearms and ammunition will not survive the court's scrutiny and most certainly not result in a conviction in either of these 2 discussed matters. I submit that this case therefore has no recovered firearms nor live ammunition. The state avers that presence, use and possession of firearms by the accused can be inferred from the spent casings found at the scene. This haphazard and ill-conceived submission by the state is clumsy and will most certainly not result in a value judgment by this court nor the trial court that the existence, presence, use and possession of a firearm capable of being discharged and was used by selected persons in the commission of alleged offences can be found to be proved or capable of being proved based on the presence of spent casings on the scene. Counts 1 to 10 rely on a firearm or firearms capable of being discharged, whilst the court would in all likeliness be advised that there is a possibility that firearms may be recovered in future during the state's address. At the time of my application, there is none. The state cannot seek to cure the lacuna in its case by adding further evidence during its address. This should have been done in its evidence being contained in its substantial affidavit filed as Exhibit G. Going back to the inference that the state is asking this court to draw, I submit that the Honourable Court is asked to infer that there were firearms, despite no firearms having been recovered nor in evidence. The presence of the shell casings cannot possibly be held to serve as an inference that there were in fact firearms that were in my possession. Evidence in the trial court would be the firearms that were recovered, tested, linked to the spent shell casings, and a bullet or bullets removed from the deceased that are linked to same. I submit that in the absence of the state being in the position to prove the existence of 2 9mm pistols in the commission of the offence with ballistic reports, and further that the same firearms are sufficiently linked to the incident, will not be capable of being proved beyond a reasonable doubt during trial. I draw the Honourable Court's attention to the submissions at paragraph 5 of Parbu's affidavit annexed to the transcribed record in my founding affidavit, in which he refers to several cases, two of which are mentioned in this case. Berea 85-223, which is this case, and Mabel 26-5 of 22. Both are murder cases to which the prohibited firearm is linked, being a Star Norinco 9mm. Barbie himself admits that it is not me, but only the firearm that is linked to the cases. There are no counts of murder attached to my case for Bheki Themba, and further, I am alone. I alone am charged. There are no co-accused in this matter. I submit that the SAPS is attempting to marry me up to other cases through the one firearm that was allegedly found in my possession or on another occasion, which is the joint possession submissions. Even in the unlikely event of me being convicted for possession of the firearm, joint possession disallowing same, I submit that a conviction would not imply use nor possession of the same firearm at any other time, giving a voice to the other matters for which I am charged. At paragraph 28 of Exhibit G, the state alleges at page 11 that a comparison with the Bheki Themba case 138-423 was made, and two of the spent casings on the scene was linked to the pistol I'm alleged to have been in possession of at the time of my arrest, for same on 24 April 2023. This is what links me to this matter. I stand by my submission supra and in my founding affidavit that it is very unlikely that I will indeed be convicted of possession of the firearm in the Bheki Themba case. This link stands on shaky ground and cannot be held to be a link at all. At paragraph 29.1, 2 and 61 to 63 of the state's opposing affidavit, it is alleged that I was called by a person, not a co-accused as we stand before court, to arrange a Mercedes and firearms. The Mercedes referred to was not alleged to have been robbed by me at any time. Arrangements were then allegedly made between myself and the unknown person that the Mercedes and firearms be delivered to the latter person at the M4 Jacobs off-ramp. After the incident, the Mercedes and firearms were returned to me. It must be kept in mind that one Mr. Ngobo is charged with the robbery of the Mercedes and not myself. The Mercedes was found abandoned and not in my possession. Mr. Ngobo is charged as the only accused for the robbery of the Mercedes. Submitting the cell phone records will show contact with myself and my co-accused that I was the person who arranged, delivered and collected firearms and Mercedes-Benz the day of this incident needs to be addressed. I annexed here to King Edward Hospital records marked KEH1 that shows that I was taken up at casualty at 2127 on 10 February 2023 with a gunshot wound to my ankle under file number 00413-063. The investigating officer has the document at page 1 of KEH1 in his docket for Bheki Themba case 138-423 pistol possession. It is apparent that the I.O. Pillay did not take this document into account when he proceeded to charge me. Perhaps he was unaware of same. There is the issue of cross-referencing the two dockets if they are linked in a manner alleged. I am unable to speculate as to why this information remained undisclosed to court, but other information was revealed. I was then admitted as an inpatient straight from casualty after being stabilized on 11 February 2023 around 1 o'clock in the morning, 12:30 at night, or yes, 12:30 at night, as page 2, Annexure KEH1. The document refers to the casualty file number, top right, OP number 00413-063. It further confirms at page 2 that I was moved or referred from casualty. My ankle was absolutely shattered and I remained on crutches until recently. The time of the shooting incident was around 22:18 on 10 February 2023. By that time, I was admitted at King Edward Hospital casualty, my admission being 21:27, and moved to the ward as an inpatient from casualty on 11 May 2023 at 12:30. I was therefore not capable of being on the scene at the time of the shooting, in a position to collect firearms and a Mercedes-Benz, and presumably hiding same as I was in hospital with a catastrophic injury. I could not have been of assistance during the incident, neither after. The Section 204 witness statements stand to be disputed by my attorney during trial if admitted in evidence, and the witnesses give evidence on same. I deny that I shot myself playing with a firearm, so alleged by the state. The state submits that it is in possession of Section 204 witness statements. I submit that the court cannot accept that the witnesses will indeed be testifying as same. Should these witnesses be one or more of my co-accused, as it stands to be by virtue of procedure, my attorney would be asking the trial court to warn them prior to giving evidence that immunity to prosecution for the admissions under oath at trial implicating themselves is not a right, but it is in the discretion of the trial court to extend and confirm same upon finalization of the trial. The basis on which a Section 204 witness is suggested is where a case is extremely weak. I submit that the Section 204 witnesses agreed in exchange for favour in some manner or form, which will be addressed during trial. It amplifies my submission that the state's case is very weak. References made to witnesses in plural, letting more than one accused off the hook, speaks to volumes as to the state's case. The state filed its affidavit and largely deals with the alleged Section 204 witness statements, setting out the content thereof in storyline with accuracy. It would be inappropriate to discuss the content of the statements herein, as the statements may be challenged during trial as follows. The document itself may be challenged by the accused during a trial within a trial, and may then be either ruled admissible or inadmissible, after which the statements would no longer be a consideration if they are inadmissible. The content would not be within the knowledge of the presiding officer. Should the content of the statement be challenged during this bail application, it will form part of the record and may be used against all the accused at trial. Disputing the content implies that the statements are deemed admitted or at least admissible during trial, as one cannot address the content of a document unless same is admitted in evidence. The Section 204 document will therefore by implication be admissible as evidence during trial against the accused, and content will be the only portion left to address during trial. I cannot address the submissions in the state's affidavit where it recites events as set out in the Section 204 statements. Looking at the storyline, it is evident that the information was obtained within the Section 204 statements and related in the state's affidavit as evidence linking the accused. It is not appropriate for me to render these documents admissible with a lengthy affidavit that speaks to the content of the statement. I therefore elect to reserve comment on the alleged 204 statements, so preserving the rights of those who are alleged to have made the statements. The only submission I am making in respect of the Section 204 content of the state's affidavit is that the statements may well be inadmissible at trial as stated above. The allegations made therein should therefore carry little or no weight at the time of my bail application. The above submissions speak to the fragility and weakness of the state's case during this application, and further the weakness of the state's case during trial should this matter ever get to trial. The state disputes that the pending matter in Mlazi deals with joint possession of a firearm. I am surprised that this issue is brought before this Honourable Court. I have annexed a copy of the charge sheet, an annexure marked A for ease of reference. The annexure reads, the accused did unlawfully and jointly have in their possession a firearm. I humbly submit that the state's case is weak during my bail application, and the weakness or fragility of the state's case is accepted by courts as being exceptional circumstances. The interest of justice does not demand that bail should be denied, and exceptional circumstances exist permitting my release on bail, and pray to the above Honourable Court to grant me bail on conditions that the court sees fit. Despite me, being unemployed due to continued incarceration, I submit that my family will be able to assist in paying bail, and I ask that the court grants me bail in the amount of 5,000 rand. So signed by my client, Your Worship. My client has read the affidavit. Understands the content, and no interpretation is required. If that may be confirmed, Your Worship.
Confirm the content of this statement, Mr. Mieza, and that it was read to you, you understood it before it is read into the record, as it was not interpreted to you. Thank you. The statement has already been accepted into the record and marked Exhibit J.
As the court pleases, Your Worship, that will be the case for the applicant 3, Your Worship.
Case for applicant 3. Back to Mr. Mr. Mlojwa.
Your Worship, before my learned friend is given the opportunity, you will recall that accused numbers or applicants 2 and 4 that there will be an application for an adjournment to this coming Monday.
Correct.
That still stands.
Correct. Yes,
Thank you.
That's my understanding.
Yes.
That is why I don't even refer to you, because my understanding is that after applicant 3, we'll jump back to applicant number 5.
Yes.
Yes.
Thank you.
Correct, Mr. Thank you, Mr. Mbaz.
Your Worship, in respect of number 5, I haven't gone through the papers before I hand them up. I'll request that I do so on Monday, not unless I can be given maybe 5 minutes to quickly browse through what the attorneys have bound together before I can read it.
The accused have to leave the caucus free proximity in any event to be taken back to court floor. So I don't think there'll be any objection to roll this to Monday for applicant on your wish. Well, not from my side, your worship.
I'm disappointed. I'm really disappointed because
Your Worship, my instructing attorney is instructing me that it's short. It can be finished within 15 minutes.
so are you ready?
There is no attachment. I thought there were also attachment to it.
So are you ready to proceed, or do you want me to adjourn for you to go through it?
Your Worship, I'm in a position to read through it because there is no attachment. It appears to be a very short affidavit. With the leave of the court, if I may hand up the original. It's only 4 pages, Your Worship, it seems. In the Magistrate Court for the District of eThekwini, held at Durban, case number 23/2156 of 24, in the matter between Lindokuhle Thabani Mkhwanazi, first applicant Lindani Zenzele Shisela Ndimane, second applicant Sianda Edimieza, third applicant Nziwa Themba Harvey Gwabeni, fourth applicant Lindokuhle Lindo Ndimane, fifth applicant and the state, the respondent. Fifth applicant's replying affidavit in support of application for bail. I, Lindokuhle Lindo Ndimane, the undersigned, hereby state under oath and submit the following. Paragraph 1. My personal circumstances are as contained in my bail affidavit filed in this honorable court in support of my bail application. Paragraph 2. The facts to which I depose are within my personal knowledge, unless otherwise stated or the context so indicates. The proposition of law herein advanced on the advice of those representing me. 3. I have heard the opposing affidavit of the investigating officer, warrant officer Kumar Rasen Pillay, herein after referred to as the investigating officer, being read into the court's record on the 27th of March 2024, and I've also had an opportunity to read it with the assistance of my legal representatives. 4. I aver that I've seen the affidavit deposed to by the first applicant, and I wish to bring it to the attention of this honorable court that in equal measure, paragraphs 4, the paragraphs mentioned in this paragraph are also applicable to me. Paragraph 5, regarding my arrest, I dispute that there was ever a time in which the police came to my homestead looking for me, except the day they approached my mother, who called me to inform me that the police were looking for me. It is the only day I spoke to the police, when the police also showed my mother where my grave would be, next to the kraal, if I did not hand myself over. I handed myself over the morning with the assistance of my erstwhile attorney, Ms. Gilling. Paragraph 6. I dispute that I ever went to Eswatini. I was within the Republic of South Africa. Paragraph 7. I cannot deny that my bank card was used in Eswatini, as it is a visual bank card loaded onto my phone in possession of one of the arrestees in Eswatini. Paragraph 8. I dispute any suggestion that I went to the airport on the day the deceased met their death. Paragraph 9. On the 10th of February 2023, I had arranged to meet a lady at Wish Restaurant. However, realizing that the clock was ticking while at Wish Restaurant and the lady was not coming, I kept calling her and she kept on promising that she will definitely come. Paragraph 10. I dispute any notion that I was a spotter, as I was not even aware that first deceased was also around. It was shortly after gunshot had ceased that I heard that there was shooting outside and that one of the victims was Mr. AKA. I did not know anything about the shooting. Paragraph 11. I deny the investigating officer's version that I changed position while at Wish Restaurant. I dispute the investigating officer's version that I was not patronizing which restaurant regularly. Paragraph 12, prior to the 10th of February 2023, I used to have personal discovery and time bank cards. Due to problems with these cards, applicant 4 used to deposit money after working as his driver, especially with long distances trip, into my brother's bank account. My brother is Fundo on Demande, but is also known as DSD. Paragraph 3. Coincidentally, I approached Standard Bank to open the bank account on the 10th of February 2023. 14. I dispute all reasons furnished by the investigating officer in opposing my release on bail. Paragraph 15. I do not dispute that for work I rendered without being paid over a period of time, that I was paid eventually 100,000 rand by the fourth applicant. The fourth applicant used to entrust me with the duty to be his driver, especially with his long trips, and sometimes there would be months in which I was not paid. Paragraph 16, the personal circumstances, the reasons I've given for release on bail, my undertaking to comply with any terms and conditions accompanying release on bail, and the fact that I've demonstrated how doubtful the state case is, make out a case that exceptional circumstances exist, which in the interest of justice warrant my release on bail. HANKA in Scott Crossley versus the state, open bracket 2007 close brackets, SCA 46 RSA paragraph 7, held that the court must consider all factors and determine individually or cumulatively they constitute exceptional circumstances which will justify the release on bail. Wherefore, I respectfully ask this honorable court to admit me to bail with terms and conditions and amount this honorable court deems appropriate, dated and signed at Durban on this 2nd day of April, signed before the Commissioner of Oaths, each page initialed by the applicant.
Do you confirm the content of this statement, which was not interpreted to you here in court, but are you confirming that it was read to you, you understand it, and you confirm the content thereof?
Statement sakho ndimanje besifunda kumele wakho manje ke konke kubhaliwe phansi uyakwazi nokuthi kuyiqiniso yizo singadolukanga la enkantolo ubuye wafundela sona ekuqaleni wa-understanda yonke into. Confirm same your
Statement which was read into the record is accepted into the evidence and it's marked Exhibit K.
As per pleases, that is the case for applicant number 5, Your Worship.
Case for applicant number 5. That leaves us with applicant number 2 and 4. And we agreed this morning that applicant number 2 and 4's replying affidavit would be ready by next week, Monday, the 8th of April. We confirm that.
Confirm, Your Worship. With that being said, it just crossed my mind as I was sitting down that for the state to make an affidavit due to certain aspects that have been raised that I knew, we'll have to await 2 and 4 if there's anything that they might raise before we can compile our affidavit. Which then brings me to an idea as to, from the 8th, which next date can we take? Before the 25th, where we are supposed to make arguments.
Yeah, when mention was made of the 22nd of April as the date when the arguments would be submitted in writing, which arguments would then be
That maybe we have a short agenda, maybe in chambers.
Yeah,
We
I
can
think that is
compare
proper.
what happens.
But I think in the meantime we can postpone the matter until Monday and then agree on the dates in chambers, which date will then be.
That's it.
Gentlemen, please rise. matter against you is postponed until Monday, the 8th of April, for further evidence. You are still in custody, Westville. Thank you.